Yes. 22. Yes.
Your Lordship, as per the cost list which was released yesterday, Your Lordship, the item was not mentioned. And however, this morning, this supplementary cost list has been released.
Yes.
So matter may be fixed on 6th, since we were in belief that case would not list for today. So we have not brought any record, Your Lordship.
You are Mr.
Jayasring.
Hmm?
Jayasring. Chambesring.
Mr. Jayasring, learned counsel for the appellant, submits that since the cause list has been supplied, this cause list has been received, the supplementary cause list wherein the this matter has been listed has been received this morning.
Yes,
for
Your
which the counsel for the appellant could not ready with the matter. Therefore, he prays for listing the matter after 2 weeks.
Your Lordship, on 6th, Your Lordship, since this is a newly filed case, Your Lordship,
Hmm?
since this is a new case, it was filed on last week, Friday, Your Lordship.
Okay.
It may be fixed on 6th, Your Lordship.
Prays for listing the matter after a week.
Your Lordship may kindly fix on 6th, Your Lordship.
On 06/06/2024.
Oblige, Your
Praise the Lord. List this matter after on so and so, 06/06/2024.
And
yes.
Your Lordship, another item I would like to mention, item number 4.
Item 4.
Yes, Your Lordship, in this case, LCR was called for and record is also received. However, the leading counsel, K. Tama, he is not in the station. This morning he has left to 0.
On the prayer of Mr. Jayasring, learned counsel for the petitioner, on the ground of the leading counsel, Mr. K. Tama, learned counsel, being out of station, list this matter after 4 weeks. 3 weeks. 18. After 2 weeks.
Highly obliged, Your Lordship.
May I please, my lord?
Yes.
I beg to mention item number 17.
17.
Yes, my lord. On behalf of O Father.
2017 matter.
My
What
lord.
is this?
RFA, my lord. RFA.
Yes.
Title suit.
It's 2017 matter.
Yes, my lord.
Who is for other side?
My lord, a consent has been taken.
On the joint prayer of learned counsel for the parties, list this matter after 2 weeks.
Yes, ma'am.
Since the matter is of 2017, the adjournment is granted as a last chance.
Deal of this.
List the court.
May I please, madam?
Yes.
Madam, I beg to mention item number 12, madam. Item number 2, madam.
Item 2.
Yes, madam.
Yes.
Since the leading counsel for the respondent is out of station.
Who?
Deep Angang, madam.
Yes. Who is for petitioner? Item 2.
Yes, my lord. I have taken consent from the petitioner.
On the consent of the learned counsel for the petitioner, Mr. M. Doji, learned counsel for the respondents, prays for listing the matter after 2 weeks.
After 1 week.
After a week, praise the Lord, list this matter after a week.
My lord, another item, madam. Item number 13, madam.
13.
Yes, madam.
Yes. On the prayer of this is orders, we'll see what is to be done.
Yes, madam. And madam, item number 18 also, madam.
18. On the prayer of Mr. M. Doji, learned counsel for the appellant, list this matter after 2 weeks.
After 2 weeks, madam. Item number 20, madam.
20 also. Same.
Yes, madam. Madam, item number 23 also, madam.
20?
23, madam. Supplementary for this, madam.
Yes, after 2 weeks.
Madam, it may be, can it be on 10th of June, madam?
We'll see. after. Item 23. Item 23.
Yes, my lord. 23.
That's Monday, then 10th, make it 10th.
Obliged.
Then in this item 23, on the joint prayer of learned council for the parties, list this matter on 10/06/2024. Yes,
Yes, I mean,
yes,
I beg to mean item number 21, my lord.
21.
My lord. With consent of the all party, my lord, may I pray this be listed after 2 weeks, my lord.
After 4 weeks.
2 weeks, my lord. 3 weeks, my lord.
Why?
My lord, I am not prepared, my lord.
Huh?
I could not prepare, my lord. With the brief, my lord.
Of 2023.
23, my lord. True.
Man is in jail.
No, my lord. No,
He's on bail. That's the reason. On the prayer of Mr. L. Permel, learned counsel for the appellant, list this matter after 3 weeks.
High level.
The Mr. V. Dulam, learned counsel appearing on behalf of
Private respondent.
respondent number. Private
Two, ma'am.
respondent
2, my lord.
is present and has raised no objection.
I have informed the PP also.
N. Sharma. Mr. B. Dulam, learned counsel, submits that new set of new councils have been appointed in this matter, for which he prays for listing the matter after 2 weeks. Will not fix that. After 2 weeks, list of. What is that? Just wait. Submits that the set of new councils have been appointed in this matter, for which he prays for listing the matter after 2 weeks. List of prayers allowed. A list after 2 weeks. Next para, registry to reflect the name of Mr. Answer, counsel for the petition in the cause list.
Please, Lord.
Yes.
I'd like to mention item number 3, Lord, on behalf of Mr. B. Picha. B. Picha, on behalf of B. Picha. Item number 3.
On the prayer of Mr.
B. Picha, on behalf of
Your name, please.
T. Gatso, Lord.
T. Gets learned counsel on behalf of appearing on behalf of Mr. B. Picha, learned counsel, but list this matter after
2 weeks.
2 weeks.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 12 on behalf of Mr. O. Modi, leading counsel for the petitioner.
It's in the orders. Listed for orders, we'll see. Wait for your turn.
Yes,
right?
sir.
May it please your lordship.
Yes.
Your lordship, this is a joint petition in connection to
What is the offense?
143, 1.
I don't know what is 143, 158. What is this?
My lord, 143. Your lordship, 143 is for punishment for unlawful assembly.
Unlawful assembly.
Yes, my lord.
148,
For rioting, my lord.
149.
That is also, my lord.
Okay. 324.
It's for
Injury.
Injury.
yes, my lord. By the injuries, we can.
What is the stage of trial?
No, my lord, they have just received summons, my lord. Yes, my lord.
That the charge sheet has been filed.
Yes, my lord.
Okay. Heard MSE permit, learned counsel for the petitioners. Next para. This is an application under section 482 CRPC, 1973. Praying for quashment of the criminal proceedings of GR case number 239 of 2020 under section 143, 148, 149, and 324 IPC. 1860 pending before the learned Chief Judicial Magistrate Alo.
Passigat.
Why you have said Alo?
No, my lord, because the charge sheet was sent to Alo, my lord. It was filed in Alo, but I think because of the
Okay, Chief
bifurcation,
Judicial Magistrate Pasigat,
it is now
Chief
pending.
Judicial Magistrate Pasigat. On the basis of the settlement between the amongst the parties.
Party.
Call for
Scan copy of LCR also.
scan copy of the trial court record from the Court of Chief Judicial Magistrate, Pasigat, MS L. Hage, Learned, additional PP, appears to state. Is there no private party?
No, my lord. The
Pending production of the scanned copy of the trial court record. The proceedings of GR case number
239.
239 of 2020
2020.
shall remain suspended. Shall remain stayed.
Next date also.
List after,
1 week, my lord.
list after, not 1
Two
week.
weeks lost.
List after 3
2
weeks.
weeks lost.
No, no, 10 days, my lord.
Why?
Because, my lord, the next date is on 21. my lord.
I have stayed the proceedings. I have stayed the
Yes, yes,
proceedings
my lord.
after 3 weeks.
Lost it. Applied lost.
Yeah, my lord.
Hmm.
My lord, this criminal petition filed under 482 for quashing and set aside of the order dated 12/9/2023, passed by the learned special judge in Pasigat PS case number 98.
Yes.
Well, my bail,
Why 18 and 19? Why two petitions? Different cases.
yes.
Your lordship, actually what has happened in this case, the accused is the common accused. Against the accused, there are three cases, NDPS cases. So in two cases, the bail has been granted earlier, but subsequently it has been cancelled in the third other NDPS case, which is, in my humble understanding, is not permissible. Because if there is a violation of the condition and a particular bail so granted, in the same case, the condition, the court should have taken that ground and ought to have.
In the case where the bail was granted.
Yes, exactly.
Not
Your
the
Lord.
subsequent.
Subsequent one. All are different cases. The learned court below, trial court has taken the cases all together in one case, which is the newly registered. In that case, without affording the opportunity to the accused, bail was cancelled. Your Lordship. This is the case, their case.
So, first case were on first case.
Your Lordship,
Second case also.
second case
Yes.
also. Initially, Your Lordship,
Three cases.
three cases, Your Lordship. First is Pasigat PS case number 10 of 22, registered under section 21A of NDPS Act. In that case, Your Lordship, the accused was arrested on 25th, and on 26th, she was produced. On 28th, 2022, accused was granted bail. On that same case only, Your Lordship. And on 23rd, 1/2023, the bail so granted on 28/2/2022 in connection with PSG PS 1022 was cancelled. Then again in PSG case 102 number 2022, new case was registered. The other case, he was found to be involved in other case. Again in that case, Your Lordship, the accused was arrested. And on 23/1/2023, the accused was granted bail in the same other case also. But in PSG case number 98, the other third case, in 12/9/2023, both the cases where bail has been granted, that case was cancelled in other case, third case.
98, case number 98 of 2023.
Wherein, Your Lordship, in the main case, the PSG 98, the main case, the bail was granted, but that both the earlier case were cancelled, Your Lordship.
The problem is, who is respondent number 2?
It's a informant.
Lordship, on
Police
last,
officer, you are-
yes, it's this IO. So IO notice has been
Yes,
issued.
where is the impugn order of cancellation?
It's a, my lord, page number 29. 12/9/2023.
6. It's in Annexure 4,
Annexure 4.
page number 29. That last paragraph is given.
PS case number
10,
10
22,
10 and
102, 22.
102.
Yes, your lordship.
Bail was granted.
Yes, earlier
earlier,
granted.
That was cancelled in this order.
Although
Sir,
this case is
but,
pertains to other case.
98,
Ni-
you have to approach.
90
ca-
in my lord, in 98 already I've been granted bail.
In 98, he has been granted bail, your lordship.
My
So
lord,
what
it's
remains there
page
now?
number 31.
What remains there now?
Only due to cancellation of my
This bail,
this order, bail
you
order.
are still under custody.
Yes, my lord, I've not
Yes.
been released from.
This is the case.
This is the.
Heard Mr. T. Tango,
Yes, my lord.
then concept for repetition. We'll take up both this together.
Yes, your
Well,
lordship.
proceed.
Yes, yes.
Second order.
That will be better.
And also had Mr. T. at an additional fee for the estate. Next paragraph. The office note reflects that the service upon respondent number 2 is still awaited. Come on.
Your lordship, yes.
By order of this court, Mr. T. at an additional PP is representing the respondent number 2, as the respondent number 2 is the informant of the police officer in the matter. List of. Next paragraph. By filing this application, filing this petition, the petitioner has challenged the order that challenged the order dated 12/09/2023 passed by the, what is this? District and Session Judge.
Special court,
Special court.
NDPS.
The special court, passed by the special court within bracket, NDPS, Pasigar, whereby the bail granted to the petitioner in Pasigar case number 10 of 2022 under section 21 within bracket A, small a, bracket close, NDPS, and what do we call it? NDPS?
Narcotic drug psychotic substance.
NDPS Pasigat PS case number, right?
Yes, yes. NDPS Pasigat PS case number.
PS case number. You write that, NDPS Pasigat case number. And 102 of 2022 under section 21 within bracket small b bracket close of NDPS Act. On the ground that the petitioner, namely Yaga Yampong,
Yes. Yage Yompang.
is involved in another case being NDPS Pasigat case number, Pasigat PS case number
98.
98 of 2023. Let's go. Next paragraph. When you were granted bail in the first case,
On
on 28/2/2022 in PS Pasigat PS case number 1022.
At page 25.
Thank you, Your
Is
Lordship.
it page 25? Yes. Next paragraph. The accused, what is the name of accused?
Yage Yompang, alias Nung Padung.
Huh.
Yage Yompang,
Where do you get it?
alias Nung Padung.
Nung Padung @Yage Yompang. In the first paragraph itself, Your Lordship.
Srimati.
Yes, Your Lordship.
Srimati Yage Yampang was granted bail on 07/02/2023 in NDPS Pasigat PS case number 10 of 2022 by the special judge NDPS Pasigat. In another case, where it is?
It's in different, your other file.
Okay,
Other
you
file.
just tell that.
Yes.
Because it will be common order.
Yes, Your Lordship. It's on 23/1
23/1
2023.
The accused was also granted in bail by the special judge NDPS in case NDPS PS case number, Pasigat PS case number
102.
102 of 2022 on same day.
23rd Pars 23.
No, this is
Annexure 3, Your Lordship. Page number 22.
okay. Same day, different date.
Different date, Your Lordship.
23/01/2023. Next one. Having granted the next para, having granted the accused person in about 2 cases, come on being found involved in the third case, being NDPS PS Pasigat PS case number 98 of 2023.
Yes.
Come on. The learned special judge NDPS Pasigat has cancelled the bail of the petitioner, bail of the accused, Srimati Yage Yampang, in the above 2 cases, accordingly. Please stop. Next paragraph. Mr. He at learned additional PP fairly submits that the learned special judge NDPS Pasigat has committed an error as the accused once granted bail in a particular case cannot be cancelled in a other cases, and then cannot be cancelled only ground that the accused is involved in other cases or the subsequent cases. Next paragraph. Records reveals that the special judge has already granted the accused in the 2 other cases. The above 2 cases being PS case, Pasigat NDPS Pasigat PS case number 10 of 2022 and 102 of 2022 or 23? 23. The accused is found to be involved in the subsequent case, another in the third case being NDPS Pasigat PS case number 98 of 2023. It is evident that the and evidently the learned special judge on the prayer of the IO in the third case, i.e. NDPS Pasigat case, PS case number 98 of 2023, the two bail orders which were passed by the learned special judge has been cancelled on the merely on the ground on merely that the accused is involved in the third case being 98 of 2020. Upon consideration of the materials of the court and the submissions of the learned counsel for the petition, as parties, I find this such an course of action cancelling the bail of the petition, the accused, namely so and so, who has been granted bail in two earlier cases, cannot be cancelled in a third and subsequent cases. The cancellation of the bail relates to the affects the liberty of the personal liberty of the persons involved, and the ground of cancellation. The cancellation of the bail and the cancellation of bail is well settled by now. Next, accordingly, accordingly, in view of the above, this court finds the impugn order dated
12/9/23. Passed in
12/9/2023.
passed in PSC.
Passed in Pasigat PS case number 98 of 2023, cancelling the bail of the accused, namely Yage Yampang, is not sustainable. Accordingly, the impugn order dated 12/09/2023, passed by Lanesh so and so, the special judge, is hereby set aside and enforced. Then,
Your Lordship, yes, Your Lordship, the liberty may be given to the learned court below, or Your Lordship may indicate the earlier bail order will resume, Your Lordship, revive, Your Lordship.
it is needless to mention that the in view of the setting aside of this impugn order, the earlier bail granted to the accused, namely so and so, shall revive. It is further provided that provided that they would not the setting aside of the impugn order shall not preclude the magistrate, the special judge, or the matter to decide for cancellation of bail in accordance with
Law, yes, sir.
if the same is warranted in the facts and circumstances of the
Yes.
matter.
Deeply obliged.
Much obliged.
Then next, both the criminal petitions are allowed and disposed of.
Obliged.
Much obliged.
Your Lordship,
Yes, sir.
this is the third subsequent value.
Yes.
Earlier, the bail was rejected by the special judge POCSO, UPI, on on 12 January 2024. The rejection was done only on the ground that the accused person is from the Manipur. And if he is enlarged on the bail, then there is a chance that he will jump the bail. So the prosecution case is that, Your Lordship,
That is the first one. What was the second rejection?
this is the second, this was the second rejection.
What
For-
is the first rejection?
First rejection was on the ground that,
Initial stage.
yes, initial stage, as well as there was the another witness to whom the IO was concerned to examine the same.
Yes. Then.
And then
Second was?
second
from
was on,
Manipur.
yes, he is from the Manipur. That's why the
So
bail.
this petition, why you are saying subsequent? Is it the subsequent petition before this court? This is the first time you're.
Yes, this is the first time before this honorable.
So that is not a subsequent.
Okay.
Yes, then.
Prosecution, accused person was arrested on 11 September 2023 on the allegation that he has touched the private part.
Stated at the bar that the next, that is fixed for consideration of charges on 10/06/2024.
Yes,
It's correct.
yes.
Let the matter be listed after a week. After 10th is what? Monday. Let this matter be listed on
11.
12 or 13. 12 or 13. 13. 06/2020. On the next date, London edition PP2. Place on record the latest status.
So let it be through Your Lordship registry because it is the trial court record.
And, Rest it to. No. The next date, the status of the trial be the status of trial be informed through the registry. 13.
Yes, obliged.
Yes, sir.
My lord, this is bail application of report 13H. In
Yes.
fact, the accused, he is behind the bar for last 5 months. Despite the fact that the charge sheet has been filed on 2nd February 2024. Although the charges are very heinous, the prosecution says that it was a murder case, but it is of course a matter of trial. It will be determined during the trial. Now, the issue is that for how long the accused should be kept in the jail. Since there is no chance of this evading the trial, nor there is a chance of this tempering the evidence, all the accused has filed bail application before the special court below. It was of course rejected only on the ground that he is the main accused in that case. Although rest of the co-accused has been granted bail earlier. So now, my prayer is that this investigation part is almost complete, not almost, rather it has been completed, and the charge sheet accordingly was filed on 2nd February. Now, the court below is fixing time for consideration of charges time and again. But since the investigation agency, they are waiting for the official report from the institute. So this could not be considered. As of now, 5 dates has been given for the consideration of charges, but it could not be considered. Now the next date is 27th of June. My humble prayer is that apart from this all allegation, I am saying that although the prosecution says something else, it is a case of murder. But my case, the case of the accused is that it was not a murder. The victim, the deceased, and the accused, they were this husband and wife. Of course, it was not recognized in the month of December itself. They were going to get married. And that fact is also not disputed even by the complainant, who is the mother of the deceased. So this accused, my lord, apart from all this, his innocence, he's only the son of his parent, accused. Now, while he was in the custody, jail, his father has also died.
It's okay.
Yeah. And
Whether
after
you are innocent or not, it's a matter of trial.
yes, yes.
Why should we grant
That's what
bail
I am submitting.
in
my-
such a serious matter?
Yes. Therefore, my lord, I am just would be relying on some judgment where it says the personal liberty is granted under Article 21 of the Constitution. It says that if the case seems to be the trial of the case will take a relatively very long time, then in such cases, the accused should be released on bail.
Those are
The
the matters.
accused should not be-
When the matters takes, years to complete the trial. Say, for example, 5 years,
Yes.
10 years, 15 years.
Now,
Yours is all hardly a few months.
yes, no, I am here in the bar, behind the bar for last 5 months.
That's why
I was arrested on 5th of
Few-
December.
Few months,
6 months, yes.
few months, few months. Few months.
The 6 months is not this.
Charge sheet was filed in
Okay.
2000 February,
Yes, February.
3 months
Now,
back.
yes, 3 months back. Now trial, since CC could not be framed, so trial has not yet started.
Yes,
Up-
any apprehension.
Your lordship,
If he is released on bail, he may,
tampering and tampering with the evidence.
yes,
His lordship.
or any custodial interrogation.
Your custody interrogation question doesn't arise at all at this stage. But so far as your lordship, the heinous offense is concerned, your lordship, it is well settled that the length of incarceration period cannot be a ground for granting bail. Because your lordship, section 437 subsection 1 Roman I is a sine qua non for granting bail even under section 439 of the CRPC. And there are catena of judgment, your lordship, and in one of the judgment, your lordship, which I've already relied, and it's in part of the record, your lordship, the Rajesh Ranjan Yadav case.
Huh?
Rajesh Ranjan Yadav case, your lordship.
No, just we'll come back there. We'll come to that, but you tell us why he should be there. Why he should be continue?
Your lordship, the offense so alleged to have been committed has to be looked into with the interest of the society as well, your lordship.
It's a murder.
Yes, your lordship.
It's okay.
Yes, your lordship.
There.
So, your lordship, the impression toward the society, the gravity of the punishment, so far as the punishment is there, if so convicted, and your lordship, the manner in which the offense has been committed, that has to be looked into, your lordship. Your lordship, and on last occasion, your lordship, I have relied one more judgment, latest judgment of the Honorable Supreme Court, which was reported in 2024 SCC Online 974, wherein, your lordship, the Honorable Supreme Court, that in that case, the parameter has been laid down, and while cancelling the bail also, the Supreme Court has held that when the allegations are so serious, even in that case, despite there is no any violation in the condition, the court can cancel the bail. So, the Supreme Court has given stress on the, your lordship,
Sir, why not on cancellation? We are for granting bail.
yes, your lordship, your lordship, the gravity of nature of the offense and the manner in which the offense has been committed, your lordship. I am stretching on the, your lordship, the manner in which the offense has been committed, your lordship. They both were there. They both were staying together, and the accused was found to be there in the place of occurrence, your lordship. And the footage, everything is there, your lordship, which is there in the TCR, your lordship.
He was there.
Yes, your lordship. He was present in the place of occurrence, your lordship. As per the record, your lordship. There are, your lordship, many circumstances where, your lordship, even the incorporation of 302, from the fact we can infer that, yes, there was no any such intention or that manner can be called out from the circumstances. But here, your lordship, the nature of injury sustained by the victim.
We'll come to that. First, let me make him submission.
Okay,
This
your
was of this.
Actually, my lord, if that be so, as I have submitted earlier also, the accused is innocent. Only the prosecution history says that it was a murder, case of murder. Lordship may infer from the situation at that point of time. Both of them were living together, the deceased and the accused, as a husband and wife. And there was also an agreement. There was a discussion in the family that they will be marrying in the month of December itself, December 2003. If a person who is living with her wife as a husband and wife, can there be any occasion that he will murder his own fiancé? Although since the marriage was not solemnized, that is why I am using the word fiancé. They were living together. Even the first wife, she did not have any objection with regard to their marriage. Only at that point of time, at the very fateful day of 4 December 2023, first wife and the son begotten from the word love, both of them came to the house where the deceased and the accused were staying together. They came, they did not say anything other than the property or whatever the accused is having, it should be transferred in the name of the son of the first wife, from the first wife. That was only the issue. There was no objection against the marriage. So they were planning to solemnize the marriage in the month of December itself.
Yes.
So this is the situation during that point of time. So when situation is such that they are going to marry within a couple of days, then how this murder can be occurred, caused by this accused? So therefore, Lordship may also see the fact. The room was locked from inside inside. When the disease did not come out, then only sensing something fall, the accused opened the door. He entered and found that she was hanging in the ceiling there. That is the story, correct story. So now the prosecution story says that it is a case of murder. Now there is a disputing fact. Therefore, this is a matter of trial. Until if my trial submission is to be admitted that since the allegation is very heinous, it is a case of murder, and therefore he should not be allowed to go on bail. If that is the fact, then I will have to wait for the trial, the end of the trial. I have a right to engage my own choice of advocate to defend myself. For that, I need to be freed from the jail. That is the law. Now, my lord, I place some judgment, my lord. It is already in the record, I believe.
Tell us what is the judgment?
Yes, judgment is, one is from Delhi High Court. The party name is Simpal Srivastav versus State. This talks about this personal liberty. It says that Delhi High Court here in this case
Yes.
has observed that the seriousness of the offense is not only the sole ground to reject bail application.
Where it is?
It is in para 15, 16, 17, 18, 19, and 20. May I read the judgment, my lord? Para 15 says, prior to this judgment, my lord, the Honorable Supreme Court of India, Apex Court has delivered judgment on the same line. It is reported in 2012, 1 SCC, page number 40. Based on the judgment of the Supreme Court that was delivered in the year 2012 and which is reported in 2012, 1 SCC to page number 40. This judgment has been delivered. Now, my lord, kindly come to para 15. There are no such limitation circumscribing the jurisdiction of the High Court or the Court of Session. On the contrary, the benefit of the first provision to Section 437(1) CRPC can also be extended while exercising the power under Section 439. This being a welfare legislation, though introduced by way of provision, has to be applied while considering release on bail, either by the Court of Session or the High Court, as the case may be. Now, para 16. At this stage, it may also be apt to refer to the decision of the Honorable Supreme Court in Sanjay Chandra versus CBI, so and so, wherein the limited circumstances under which the liberty of an under trial could be circumscribed were articulated in the following words. The object of bail is to secure the appearance of the accused person at his trial by a reasonable amount of bail. The object of bail is neither punitive nor preventative. Deprivation of liberty must be considered a punishment unless it can be required to ensure that an accused person will stand his trial when called upon. The court, or more than verbal respect to the principle that punishment begins with after conviction, and that every man is deemed to be innocent until duly tried and duly found guilty. Detention in the custody pending completion of trial could be a cause of great hardship. From time to time, necessity demands that some unconvicted persons should be held in custody pending trial in India. It would be quite contrary to the concept of personal liberty enshrined in the Constitution that any person should be punished in respect of any matter upon which he has not been convicted, or that any circumstances he should be deprived of his liberty, most extraordinary circumstances. Apart from the question of prevention being the object of refusal of bail, one must not lose sight of the fact that any imprisonment before conviction has a substantial punitive content, and it would be improper for any court to refuse bail as a mark of disapproval of former conduct, whether the accused has been convicted for it or not, or to refuse bail to an unconvicted person for the purpose of giving him a test of imprisonment as elation. Now, from this judgment, which in fact has been passed relying on the judgment delivered by the Supreme Court in Sanjay Chandra versus CBI, it says that personal liberty should be given priority until and unless now, it says, my lord.
But this case was of not 302.
That is there, but the principle.
Next.
Principle. Next is, my lord, this is our own Supreme Court judgment, 2011, 8, Supreme 270. Para 26, 28, 29, and 30. My lord, let us straightway come to para 26 first.
2011.
Yes, my lord. My lord, this case is reported in both 2011 and 2012. In 2011, 8 Supreme, it is reported, and 2012, I have just reported, I have just read that para.
CBI.
Yes, CBI.
Vinod Goenka, Sanjay Chandra.
Yes.
Again.
This is a common judgment.
Not required.
Yes.
Then
my lord is now there is another judgment, my lord, rendered by the Delhi High Court. Sanjay Kumar Manchandra versus State of Delhi. I will be referring to para 8, 9, and 10. My lord, I have already submitted that one copy of that judgment.
Which one?
Ajay Kumar Manchandra versus State of Delhi. It is judgment rendered by Delhi High Court. My lord, may kindly come to para 8, 9, and 10. Rest. The right, it says, is evident from the record,
42408.
my lord.
42408.
My lord, I could not follow, my lord.
This is a 408.
Yes,
420.
yes, yes.
It's not 302.
But, my lord, only what I am trying to submit is that the principle, why the further detention of, even after the filing of charges is required, my lord. If there is no need of custodial interrogation, the accused should be enlarged on bail. The principle laid down by the Supreme Court and the rest of the High Court. I am just emphasizing on this issue, this point. At para 8, it says, as is evident from the record, the
Okay.
dispute involved.
Then, next.
Then, my lord, next one is again from this Punjab and Haryana High Court, the Jasbeen Kumar versus State of UT Chandigarh, para 6 and 7. This talks about prolonged trial,
370.
prolonged trial and presentation of charge sheet.
370.
Yes,
Not 306.
Yes.
302.
yes.
Then?
No, I all this judgment only with me.
Yes.
Now, only the principle, my lord, kindly come to,
Principle is well settled.
yes,
It is related to the facts of the matter as well as the prima facie material and the seriousness of the offense.
my lord, till the completion of the trial, my lord, that means, my lord, one has to be there in the jail.
We don't know. If the principle says so, no other option.
The principle says that, my lord, this Article 21 of the Constitution has to be given emphasis.
Principle also said the seriousness of the offense has to be considered
Again, there,
based on the
here in
material.
all these cases, my lord, this, the prolonged trial, the time which will be taken for the trial. If it is that no, the trial cannot be concluded within such
No, those
period,
are the
then
cases
this
where
honorable court can
the accused has been allowed
grant
to
bail
be
to the accused on that count also.
incarcerated in a jail for 10 years, 15 years on such a situation only.
That,
So
will
your
am-
ground
amount-
is that
that will, my lord,
charge sheet has already been filed
yes,
and there is a likelihood of prolonging of the trial and there is no custodial interrogation.
yes,
No custodial interrogation is required.
is required.
And then
And that there is no chance of this tempering the evidences. My lord, because the parameter for consideration of, for granting bail,
we are
it is
conscious.
it is very simple.
We are
My lord,
conscious.
my lord, the honorable court only has to see. Of course, I'm not saying that this seriousness of the allegation is not to be considered. It has to be considered. But having considered that fact also, my lord, if the honorable court finds that, my lord has seen the judgment just which I have placed. My lord, it should not be punitive. And it should also not be this preventative. All the courts, my lord, honorable Supreme Court also holds that punishment begins from the conviction. My lord, I have not been convicted yet. Trial is yet to start. Only CC stage is there.
Who says the punishment begins prior to the conviction?
Yes, it's like a punishment only, my lord, because my lord, has seen.
You are in judicial custody.
Investigation part is complete. That is why they have submitted the charge sheet
Are you being,
on 2nd February.
are you being tortured? Are you in police custody?
This, my
You
lord,
are in judicial custody.
to put me behind the bar for such a long time, despite of the submission of the charge sheet, that is not punitive, my lord. I am asking this question to myself.
You, your,
Is
you
not, my lord,
yourself
this
has
a-
said the FSL report is yet to be received. FSL report.
Yes.
It's a crucial the
My,
material.
my lord, the accused, he is just a layman. He will not have any access to this, all this process of this FSL report and all. Everything has been collected and it has been sent for FSL report. I'm not that smart, my lord. I cannot follow this, all this proceeding. Only the thing is that, my lord, they have submitted this charge sheet. Investigation is complete. There is no chance of fleeing away from the trial. There is no chance for tempering the evidence. My lord, if my friend from the prosecution side says that there is any chance of this fleeing away from the trial, then, my lord, I'll just withdraw this application. Even if they say that, my lord, there is chance of tempering the evidence, I'll gracefully withdraw this bail application.
What did you say?
My friend from the prosecution side, if they say that there is a chance of this tempering the evidence by the accused, my lord, may straight to reject my application.
Not reject. You said you will withdraw. You make a statement that there is chances of tampering with the evidence. You make a statement. Let him withdraw. Let's see how
I'm sorry, my lord.
how he's up to his work.
Because the Harsim, my lord, I can also appeal. The accused, he's behind the bar since 5th December. I can appeal the
It's a
hardship.
serious matter.
That is why, my lord.
There's an allegation of murder against you. You are the main.
That is only
accused.
allegation, my lord. That is why, my lord, I have submitted. That is the story, prosecution story. And my lord may
innocent
kindly,
lady-
my lord, this
Lady
honorable
has
court may,
lost her life. You are just talking about your life only. What about the person who has lost her life?
that
You
my
are
lord,
only worried about your 5 months
that is
incarceration.
why, my lord, I am submitting that. That is for the trial court. After trial only, that will be decided, my lord, whether it was a murder or it was a suicide. Before the determination of death penalty, my lord, how even the prosecution can say that, yes, it was exactly a murder. It is not the police who will decide, my lord. It is the court. After trial only, it will be decided whether it was actually a murder or,
But as of now, we are in bail jurisdiction.
my lord, yes.
We are not here to
Absolutely.
decide
That is
the
why,
guilt or innocence of you. Right?
my lord,
We'll consider,
word of-
we will taking into parameters of granting bail, will consider your in the bail jurisdiction.
my lord, my lord.
Will not saying, but the allegation as on today, it's a 302, it's a serious allegation.
That is,
I mean, heinous
yes,
crime.
ma'am. 302 is very serious allegation, my lord. I am also admitting that, my lord. But what I am submitting is that it's not a 302 case. My lord may not kindly take the word of the prosecution as a gospel truth. They can also, my lord, for the sake of this filing search, they can make out any story, my lord. That is what my lord has seen.
We take
The conviction rate in the country, my lord, it is very low because of the fact that these police, those who take up the investigation, they make false stories.
Is it?
Yes, my lord.
You don't faith in the system.
So therefore, my lord, all this, apart from all this submission, my lord, my only humble submission would be that, my lord, there is no chance of fleeing from the trial, my lord. As, my lord, they have already submitted the charge sheet, my lord.
The accused,
That cannot be tempered, my lord.
which
Charge
is-
sheet will remain there in the court as
a person who is accused of
In the same,
murder and standing on the trial is saying that the police makes a false story. It is hard to believe and hard to accept. Anyway, that's all.
my lord, yes, the three parameter, my lord. No change of plea, away from the trial, my lord.
Yes,
There is no change of temporary,
yes.
my lord.
Then there's a chance of prolonging the trial.
Yes, my lord.
And,
And
and
personal
only
liberty,
three.
personal liberty being
There is
the
four-
paramount, my lord,
Okay.
which is has been enshrined in this Constitution of India, in Article 21, my lord. And my lord, the man who is behind the bar since last 6 months, he's only the lone bread earner of his family, my lord. So, put this keeping him behind the bar for further period, my lord, that will hamper the life of his son and the first wife, my lord. There is no one other than the accused to look after these people, my lord. So this aspect may also be considered because, my lord, this I know, my lord, to grant bail and rejecting bail is the prerogative of the court, my lord. But the welfare of the accused, my lord, until he is proven guilty, my lord, let him feed his son and his family. Why they should be deprived of the support from the father, my lord? All these aspects, my lord, may kindly be considered, my lord. As I am repeatedly submitting, there is no chance of this clean trial. He is the permanent habitant of Alo only, my lord. He is having his own property. He cannot flee away from Alo, my lord. Obliged, my lord.
Your Lordship, I will start with this line that my learned senior colleague has stated, that no one should be deprived of its personal life and liberty except in accordance with law. Your Lordship, the itself says that one should be deprived of his personal life in accordance with law. And law of bail is very clear, well settled, Your Lordship. If it was a case where the punishment is not life or death, Your Lordship, in that case, Your Lordship, the embargo under 436 subsection A would not come into play, Your Lordship. But since there is material indicating the complicity of the accused in the commission of the offense, Your Lordship, so, Your Lordship, that the embargo, Your Lordship, under 436(1) subsection A, that has to be overcome by the learned, Your Lordship,
What is that?
the embargo under 436 subsection 1, Roman I, Your Lordship, which read as
436?
Your Lordship, 437, sorry, 437 1, Roman I, Your Lordship. This is one of the parameter which is of paramount importance, Your Lordship.
37?
Yes. When bail may be taken in case of non-bailable offense. I says, such person shall not be so released if there appears reasonable ground for believing that he has been guilty of the offense punishable with death or imprisonment for life, Your Lordship. Basing on the material, the court has to satisfy itself that yes, if there is no reasonable ground to believe that the accused is guilty or involved in the commission of the offense, then no doubt, Your Lordship, he is entitled to
It's
be
not Roman I, it's Roman 1.
Roman 1, yes, Your Lordship. So this is the sine qua non, Your Lordship, even in granting bail under section 439 of the CRPC, Your Lordship. This is to be taken into consideration. So now, even from the charge sheet, Your Lordship, and Your Lordship, at this stage, the presumption that the accused is innocent will no doubt it will be there. At the same time, the presumption that the material collected by the investigation authority is true and correct will always be there unless the same has been reviewed during the trial while considering the bail petition, Your Lordship. So now, so far as the charge sheet is concerned, Your Lordship, it clearly reflects in the charge sheet because the now matter is consideration for CC, for framing of charge. And basing of all this material, the charge will be framed, no doubt, Your Lordship. But so far as the submission regarding custodial interrogation, it's not that it's not, Your Lordship. This is not the stage regarding custodial interrogation, Your Lordship, because that part is already gone. Now the accused is in judicial custody, Your Lordship, and his right has been violated or curtailed in accordance with the law. Because he's involved, he's alleged to be involved in heinous offense, Your Lordship.
But then it cannot be a punishment.
Yes, Your Lord, it's not a punishment, Your Lordship.
But if without requiring him to be in custody.
But Your
just
Lordship,
because he is alleged in a heinous crime.
yes, Your Lordship. Your Lordship,
What is the requirement of having him in the judicial custody?
Your Lordship,
Is there any chances of tampering the evidence?
these are the, Your Lordship, statute requirement, Your Lordship.
It's all right.
Yes, and secondly, Your Lordship, the statute itself
Is it
provide,
a
Your
law,
Lordship.
is it a law that once a person is alleged of a heinous crime, he should not be granted bail?
No, Your Lordship. At the same time, Your Lordship, for
What is
granting a
what
bail,
is the purpose of arrest and putting him behind the, judicial custody?
Your Lordship, the interest of the society has to be looked into, and the principle.
So,
Yes.
he is released on bail.
Yes, Your Lordship.
It will
Your,
have an adverse effect on the society.
yes, Your Lordship. The first very requirement which I've shown, Your
See,
Lordship,
you
that
cannot have a one-way, kind of embargo. Law is meant for people. Is not it?
yes, Your Lordship.
Unless you can show that if he is released on bail, it may hamper or tamper with the evidence. And it's the chances of fleeing from the justice. And unless it will affect the trial, what's the use of putting? Why he should be allowed to be incarcerated in the jail?
And what about the, Your Lordship, the manner in which the offense has been claimed? That is also one of the factor, Your Lordship.
That we consider that is a matter of trial now. You have filed a charge sheet
No,
now.
even in bail, Your Lordship, that has to be looked into. Your Lordship, may kindly, I would like to rely on.
Look into, but then it's not that we cannot look into. But apart from,
Because, Your Lordship, the statute also provide the detention, Your Lordship, under 436 sub A, clause A, Your Lord, 436A also.
yes, which judgment were you
Your Lordship,
Rajesh Ranjan Yadav.
no, Your Lordship, 2024 SCC online, SC 974, Your Lordship.
What about this? Rajesh Ranjan.
Rajiv Ranjan, yes, there is also the principal parameters has been given. Your Lordship, may
Page,
page para 10, Your Lordship. It's 2007 1 SCC 70 from 10 para.
in our opinion,
Yes, Your Lordship.
just read it.
In our opinion, none of the aforesaid decision can be said to have laid down any absolute and unconditional rule about when bail should be granted by the court and when it should not. It all depends on the fact and circumstances of each case, and it cannot be said that there is any absolute rule that because a long period of imprisonment has expired, bail must necessarily be granted. As observed by this court in State of UP versus Amarmani Tripathi, White, para 18, 19, so and so, 18. It is well settled that the matter to be considered in an application for bail are whether there is any prima facie case or reasonable ground to believe that the accused has committed the offense. 2. Nature and gravity of the charge. 3. Severity of the punishment in the event of conviction. 4. Danger of the accused absconding or fleeing if released on bail. 5. Character, behavior, means, position, and standing of the accused. 6. Likelihood of offense being repeated. 7. Reasonable apprehension of the witness being tampered with. 8. Danger of course of justice being thwarted by grant of bail. While a vague allegation that the accused may tamper with the evidence or witness may not be a ground to refuse bail, if the accused is of such character that his mere presence at large would intimidate the witness, or if there is material to show that he will use his liberty to subvert justice or tamper with the evidence, then bail will be refused. We may also refer to the following principle relating to grant or refusal of bail stated in Kalyan Chandra Sarkar versus Rajesh Ranjan. The law in regard to grant or refusal of bail is very well settled. The court granting bail should exercise its discretionary in a judicious manner and not as a matter of course. Though at the stage of granting bail, a detailed examination of evidence and elaborate documentation of the merit of the case need not be undertaken, there is a need to indicate that in such order, reason for prima facie concluding why bail was granted, particularly where the accused is charged of having committed of serious offense. Any order devoid of such reason would suffer from non-application of mind. It is also necessary for the court granting bail to consider, among other circumstances, the following factor also before granting bail. They are the nature of acquisition and the severity of punishment in case of conviction, and the nature of supportive evidence, reasonable apprehension of tampering with the witness or apprehension of threat of the complainant, prima facie satisfaction of the court in support of the charge. This court also specifically held that the condition laid down under section 437(1) is sine qua non for granting bail even under section 439 of the code. In the impugn order, it is noticed that the High Court has given the period of incarceration already gone by the accused and the likelihood of trial concluding in the near future as ground sufficient to enlarge the accused on bail, in spite of the fact that the accused is in charge of an offense punishable with life imprisonment or even death penalty. In such cases, in our opinion, the mere fact that the accused has undergone certain period of incarceration, 3 years in this case, by itself would not entitle the accused to be enlarged on bail, nor the fact that the trial is not likely to be concluded in the near future, either by itself or coupled with the period of incarceration, would be sufficient for enlarging the appellant on the bail when the gravity of the offense alleged is severe and there are allegations of tampering with the witness by the accused during the period he was on bail.
Yes.
The material so collected is also an important factor, Your Lordship. This all are, Your Lordship, not exhaustive but illustrative in nature. As
It's also said, unless there is the consideration of chances of tampering with the evidence
Yes.
has also been looked into.
yes, that is one of the aspects, Your
It
Lordship.
is not
Coupled with
only the heinousness of the crime, at least the offense, and the likelihood of
yes,
conviction.
yes, Your
It
Lordship.
also the likelihood of the chances of tampering.
Tampering, yes, Your Lordship.
That's what I'm saying. It's
Yes.
not.
Yes, it's also one of the factors. I'm
One
not.
of the factor.
Yes, Your Lordship.
I'm not
And-
saying that it's not.
So basing on this judgment, Your Lordship, the material, all the materials which has been collected by the investigation authority, that has to be looked into. If court find that yes, that person has been falsely implicated, or there is a reasonable ground to believe that he is not guilty, then while recording the court satisfaction, the accused may be enlarged on bail, Your
That's
Lordship.
not in a certain stage, not at this stage.
Your Lordship, this even this judgment pertains to bail only, Your Lordship, where it has been deteriorated.
Then next,
The next is, Your Lordship, 2024 SCC online SC 974, Your Lordship.
paragraph.
Paragraph, Your Lordship, 25. 25, Your Lordship, 25 is not relevant. Para 26. Relevant parameter for granting bail.
Yes.
While considering as to whether bail ought to be granted in a matter involving a serious criminal offense, the court must consider relevant factors like the nature of the acquisition made against the accused, the manner in which the crime is alleged to have been committed, the gravity of the offense, the role attributed to the accused, the criminal antecedent of the accused, the probability of tampering of the witness and repeating the offense if accused are released on bail, the likelihood of accused being unavailable in the event bail is granted, the possibility of obstructing the proceeding and evading the court of justice, and overall desirability of releasing the accused on bail. Here also, this case, the same case, Rajesh Ranjan Yadav was reiterated. It is equally well settled that
So
bail,
it's considered on the desirability of
overall desirability.
releasing the- Yes,
Yes. So, Your Lordship,
that is the most important, relevant thing.
yes, Your Lordship. I am on, Your Lordship, 437 subsection 1, Your
That
Lordship.
is one part.
Because
You cannot brush aside, that will definitely consider.
Your Lordship, the parameter, the aspect which has the ground, the principle which has been
This
laid
is
down.
not the only ground that has to be considered.
Yes, Your Lordship. It cannot be
There are
pick and
other
choose
fa-
ground, Your
other-
Lordship.
Other factors which need to be considered also.
Yes. And Your Lordship, it says the manner in which the offense has been committed. Your Lordship may kindly come to the charge sheet, Your Lordship. The materials so collected by the investigation authority. Page number 38, Your Lordship.
of the
Their petition, Your Lordship.
bail petition.
Yes, Your Lordship.
Yes.
Yes, Your Lordship, during the course of investigation, second para. May I read, Your Lordship?
Yeah.
During the course of investigation, I have scanned the CCTV footage of ill-fated evening, that is on so-and-so date, which was collected from the house of accused. He is the accused, Your Lordship. So-and-so at Old Market, Alo. During the CCTV analysis, it is learned that around 17-18 hours, alleged accused so-and-so come out of the house and again enter the house at around 17:20, along with his first wife, Sri so-and-so, and their eldest son, so-and-so, so-and-so. It is found from the footage that so-and-so talked with someone over phone, and from her expression, it is revealed that she was arguing someone over phone. After that, she, along with her son, so-and-so, left the residence of alleged accused. They almost spent around 40 minutes there. After departure of Srimati so-and-so and so-and-so, the accused started arguing and fight, wherein clearly seen that so-and-so assaulted late so-and-so several times. In the statement of so-and-so, he stated that he was at the residence of grandfather, Sri so-and-so, from itna hours to itna hours. But from the footage, it was found that he went out from his house at so-and-so hours and come back at so-and-so hours and again fight with late so-and-so. In his statement, so-and-so stated that he broke the bedroom door after so-and-so hours and found the deceased was hanging in the ceiling fan with sari of her late mother. But from the footage, it was found that he already broke the door at 19 hours and started assaulting with the deceased. During so-and-so hours, it was seen from the footage that accused carries plastic red mark from attached toilet in their bathroom room. After that, late so-and-so was never seen against the accused.
Against the accused should not be.
Yes, yes, Your Lordship.
Consider that.
Yes, Your Lord.
Disposed of, I'll go through the
My lord.
judgment.
My lord, may
Also
kindly
order.
also see para 35 of this. I placed the judgment, my lord. Sanjay Chandra case. Sanjay
That
Chandra
has been
case.
relied on Delhi, that thing, Delhi matter, Delhi High Court.
Lord, this, of course, this is Delhi High Court judgment, but
No, we cannot, I mean,
the principle adopted by the Supreme Court in this 2012 judgment, this judgment has been rendered.
but all the cases which you have relied on, it is not related to 302. Rather, the cases he has relied is 302.
Lordship,
Principle is well settled. And we'll have to consider.
and Your Lordship,
It also
on the-
says,
on the
my lord,
materials
this
of each
judgment, my
case.
lord, it also says that, my lord, the court, while this taking up the bail matter, it should also consider right to bail should not merely be denied because of the sentiment of the community. It also refers this sentiment of
He is not
the
saying
community,
so.
and this putting the accused behind for such a long period, it will burden the government also.
No, what he's submitting it is that the section, while considering bail in such a case, the section 347,
437,
437,
Yes.
1,
subsection 1, Roman 1 is to be,
My lord,
Take
that
into
my
consideration.
lord, that is there. My lord, also one of
and
the,
it's a sine qua non
also one
for
of the
granting
fact.
bail. Once
Yes,
it
my
is
lord.
sine qua non,
Yes,
without
I have gone to-
cross that hurdles, we cannot grant you a bail,
My lord,
according to him. You
yes,
make a
yes,
submission on that.
yes, my lord. This is, of course, my lord,
You have to overcome that. You have to
My-
cross that.
my lord. So
Hurdles.
that is why, my lord, this while granting bail, my parameters, my lord, what the parameters which need to be considered, my lord, this is that, my lord,
So if we consider this
Yes.
aspect, one of the parameter
one of the.
which he has raised, we
Yeah.
cannot grant you a bail
Yes, till this
till you are convicted.
completion of the trial, my lord, I cannot be grant bail. If
No, no.
this is to be strictly followed, my lord. That is why, my lord, while taking up these bail matters, my lord,
Which parameter
co-
has to be
co-
followed?
court has framed so
parameters-
many
The
parameters. my lord.
parameters which you have raised,
Yes, my lord.
or the parameter which he has raised, which one has to be followed? Which should be given preference?
My lord, there is,
According to you, it should be your parameter which you have relied on. It has to be given preference.
my lord, yes, my lord, because to defend oneself is also the right, my lord. While considering this any bail application, my lord, while they're behind the bar, my lord, nobody can defend himself properly. That is why, my lord, while I'm considering this bail matters, my lord, this honorable court and even the apex court has considered that, my lord, the accused, while they are being behind the bar, my lord, he won't be able to defend his case properly, conduct his case properly. That is why, my lord, in catenary of judgment, my lord, honorable apex court has emphasized that, my lord, the accused should be released on bail so as to enable him to defend himself properly. That is also the, my lord, criteria, this parameter, my lord, which has been taken
Okay,
care
I'll
of by,
consider.
yes. So, my lord,
We'll consider all parameters.
my lord,
And your lordship may kindly see, last, your lordship, it's a statutory provision that is 436A. They provide the detention, speak about the detention, your lordship.
And Mr. D. Learned Counsel for the petitioner. And also had Mr. D. at the Learned Edition for district. This is a bail application. The section 439 of CRPC. Praying for grant of bail. Praying for release of the accused, namely Tony Lolen, on bail in connection with the PS case number 74 of 2023 under section 302, 120, capital B, 507, 34 IPC. Was arrested on when?
my lord,
When he was arrested?
512,
5/12/05/12/2023.
yes, my lord.
Who is the FIR?
My lord, FIR,
Page number 14.
page number 14.
14, 15, in excerpt 2.
Initially, it was registered
Yes, UD case was
UD case.
registered, my lord.
under section 306.
Yes, under section 174, it was registered, my lord. UD case number 05 of 2023, under section 174.
Arrested on 06/12,
My
not
lord,
5.
I was arrested in the night of 5/12, my lord.
But you have said 06.
My lord, it has been wrongly written in my para, my lord. My lord. Yes, my lord, I have marked it, page number 6, my lord. Wrongly written as 06. But actually I was arrested in the night of 5. 5 p.m.
Next matter. The case of the prosecution is that on 05/12/2023, at 17 hours, a return FIR was filed by one Srimati Yari Ruchi to the effect that her deceased daughter, namely Julie Ruchi Ajabov, 25 years, got married to the accused Tony Lawler around 2020, in the year 2020, and started living with him. And after a few months, the accused Tony Lawler started torturing her daughter, sister. On 04/12/2023, the elder sister of deceased MS Yapi Ruchi received a phone call from the deceased around 7:30 hours and informed that the first wife of accused Tony Lauren has arrived at her residence and forcefully asked deceased to vacate her residence. Again, at around 18:25 hours, deceased told her elder sister that Tony Lauren has verbally warned her to vacate the residence, and further, the first son of Tony Lauren has warned the deceased not to give birth to any male child as it will divide his share in the property. It is also alleged that first wife of Tony Lauren has also called her elder brother, namely Lidu Ruchi, warning that he must take his sister back from his residence. Further, the deceased made a call to her brother that she has been brutally assaulted and sustained injury on person, lastly at 01:00 hours. She received a call from police that her daughter has been brought dead at General Hospital, Alo. Upon reaching there, she found that her daughter's clothes was full of blood and there were injury marks on upper back, shoulder, thin abdomen parts, bruises on right hand, face and neck. The disease was bleeding from lower abdomen. Next paragraph. On receipt of the information, initially, the case was registered being Alo PS case number 74 of 2023 under section 306 of 2034 IPC. No, before that. Not duty case, huh? Registered as Alo PS case number 70 of 2020 under section 306 of /34. Thereafter, on the information of the accused Tony Nolan, a UD case by Alo PS, UD case number 05 of 2020 under section 174. CFP was registered. Next one, after completion of the investigation, the police has laid down the charge sheet under section 302 of the 120 B, capital B, 506/34 of IPC against the accused Tony Nolan. And how many others? 3 others.
3 others.
Right? Gary, Nick Nolan, and Tom and Tinkle Nolan.
Yes.
3 others.
3 others.
3
yes.
others.
Accused and 3 others.
See, Tony Nolan and 3 others. huh?
Yes, Tony Nolan and 3 others.
The
Total 4 accused.
court has the investigating authority has prayed for omission of section 306 and resigned the UD case as mentioned above. The how many witnesses?
17.
The police also submitted a list of 17 members of prosecution witnesses. From where do you get it?
My lord, the charge sheet, from the charge sheet, my lord.
It's 14.
14 years. Page particular 13, page number 36.
Yes. The police has also submitted. No. The submitted 14 members of prosecution witness to be examined during the trial. It is informed that the stage of the trial is for consideration of charges.
My lord.
Will continue.
Yes, sir.
I'll examine and then
Okay.
the submission will be recorded.
Yes, sir.
All right.
All right.
Oblige.
Continue. This is what?
It's a criminal appeal, Your Lordship. POCSO matter. Service.
Yes. Why this has been listed today?
Perhaps, Your Lordship, service is not completed.
Yes.
It's a POCSO matter.
Office note. Dated Hardy Learned Council for the parties. Office note dated. We will just record simply. Mr.
Mike.
Health Ticket appears for is present. Mr. T. Learned Center is also present. Office note next for 18/05/2024 reflects that AD card is yet to be received. in respect of service of notice upon respondent. This after 3 weeks.
If maybe fixed on 24.
3 weeks.
Service not completed. In item number 10. Your Lordship, in item number 10, the petitioners, they have not taken steps yet. As per the office, not your Lordship.
Who is to take steps?
Petitioner.
Award service reports. This after 3 weeks.
Okay. Item 11, service awaited, your Lordship.
This is the one you have to take steps.
Your Lordship, okay.
No,
Last occasion, your Lordship,
yes, not this one. What was the early one? You have given me the wrong. This is item 10. Show me that early one. In that case, item 10, petitioners to take steps for service of notice upon respondent number 2 within this one. Give me that. Item 10.
Sukhwinder Singh.
Yeah. Petitioners to take steps. No. Non-appeals for the petitioner. On call. Next para. Office note dated 01/06/2024 reflects that no press steps have been taken by the petitioner. Next para. The non-constable petitioner to take steps for service of notice upon respondent number
2.
2 within a week, list after 4 weeks. Then item 11. You give me item 11. Yes,
Service not completed, your Lordship.
service, award service. Mr. T at one addition to a service report in respect of respondent number
2, 3, 4, and your Lordship. Yeah, ma'am.
1, 2, 4, and 5.
Yes, 1, 2, 4, and 5.
No, award service reports in respect 1, 3, 4, and 5. This after
3 weeks.
3 weeks.
Yeah, Lordship.
Yes,
Lordship, I'm appearing on behalf of Mr. O. Modi, leading counsel for the petitioner.
yes.
Lordship. Matter may be adjourned for today, madam.
Why?
He is out of station, madam.
Who appears for the respondent? M. Doji.
I have taken consent from respondent side, madam.
On the prayer, non-counsel for the prayer list is made after 3 weeks, list of next para. In the meantime, the respondent may file their affidavit, their response.
Deeply open.
My lord, in the last occasion, my lord, the TCR was called for, my lord.
Office note, I heard Mr. M. Doji, non-counsel for the petitioner, appellant,
Petitioner, my lord.
petitioner. Office note dated 01/06/2024 reflects that record is yet to be received. reminder. Registry to send reminder.
Right, Lordship.
Obliged.
May I plead your lordship?
Yes.
My lord, this is appeal against conviction, but today, my lord, we are on the IA, IA 12
IA for what?
for suspension of sentence and for bail, my lord. Because, my lord, the convict has been in behind bar since his conviction 22 September last. So he has
Yeah.
been in jail
Record is there.
for nearly 9 months now, my lord.
Record is there.
Yes.
Conviction under?
Section 354A of IPC and Section 8 of POCSO Act, man. 3 years and 6 months.
Third, Mr. N. Pada, Learned Counsel for the appellant. An applicant. No, appellant, Mr. Record is received. Registry to prepare paper book. Third, N. Pada as well, and MS. You report the presence of additional PP then, and for respond number two. POCSO will decide. Bail on what ground?
Lordship, after conviction, my lord, the
Yes.
mother of, grandmother of the convict, my lord, she expired, my lord. And there is, my lord, it may, although town is.
Grandmother.
Yes, my lord. There is, my lord, a popular practice, my lord, although it may sound strange, my lord, they still practice animistic way of life, my lord. After, after the death of the grandmother, my lord, there is a ritual called Dodgang Punam, my lord, where all the family members, my lord, are mandatorily to be remain present, my lord.
When?
And my lord,
For how many days?
it takes 5 or 6 days, my lord.
We'll consider what it is likely to take.
Any time within 1 year, my lord. So he's in.
So we'll
he's-
consider, we'll ask them to prepare paper book and then consider. The record is received, Registry to prepare paper book. List the matter. In main, list the matter after preparation of the paper book. Then in IA, so and so, in IA, that the matter be listed after 3 weeks. Listed. We'll consider after 3 weeks. But it's unlikely. It's better to go for final disposal of criminal appeal. All right. But we'll consider your bail application on after 3 weeks. All right. Yes.
Lordship, today, Lordship, enter an appearance, Lordship, on behalf of respondent, Lordship. To respondent, Lordship.
Okay. So
Lordship, this matter may be list, record is there, Lordship. Then, Lordship, next week, Lordship, this matter may be fixed, Lordship. On admission column, Lordship.
yes. Going to file any objection? No.
Lordship, this is the revision, Lordship. So there is a record is there, Lordship.
That's why I'm saying.
Yes, Lordship.
If you want to have file any.
No, Lordship.
Mr. K. Lolan, counsel for the petition. Mr. Learned counsel, counsel enters appearance on behalf of all the respondents,
Two respondents, Lordship.
1 and 2.
Yes, Lordship.
List the matter for admission hearing after 2 weeks.
Lordship, 1 week, next week, Lordship, its issue is,
After a week, we'll
yes,
see.
Lordship, much better.
There is an interim order, Lordship.
Interim order for escalation continue.
Much better.
Deeply obliged.
May Your Lordship.
Yes.
Your Lordship, this is a joint criminal petition filed under section 482 of CRPC for quashing and setting aside of charge sheet number so-and-so corresponding to ITA PS case number so-and-so dated so-and-so registered as GR case number so-and-so under section 380 of IPC, Your Lordship. There has been amicable settlement between the parties. The petition number 1 sees the complainant and petition number 2 sees the alleged accused. Your Lordship, FIR was lodged on dated 02/07/2021, and it is annexed as Annexure 1 in page number 18 to 27. And initially, the case was registered under section 379 of
Where is
IPC.
that, type copy?
Type copy is at FIR type copy is at page number 22 of my petition, Your Lordship, page number 22.
Where it is?
Yes, Your Lordship.
Where it is? Type
Page,
copy.
page number 22, Your Lordship. Page number 22. Main FIR is at page number 23 in para 12. May I read the FIR, Your Lordship? Your Lordship, during the pendency of this trial, both the parties have settled the matter.
Charge sheet has been filed.
Yes, charges had been filed. It is in evidence stage. However, Your Lordship, since both the parties have settled,
Evidence, what evidence?
PW,
Prosecution witness?
yes, Your Lordship.
It's over.
No, it's not over. Since the matter had been stayed by this honorable court, it is the matter.
It not seems, it has been stayed, proceedings had been stayed.
Yes, sorry.
We'll see it next week.
Your Lordship, it may
You
consider,
are for respondent number, who has stolen your ATM? Respondent number 2, petitioner number 2.
yes. But she is my niece and she is in her mid-20s. I mean, there sometime
Why you have to then file a FIR? You should not have.
because I was,
She's your niece.
yeah, no, she is junior. I was in misunderstanding. I was in misconception that she have took my FIR. Yeah, sorry, she have took my ATM. But then there, the actual fact was that I have misplaced.
Okay, her
misplaced it.
MS, so it's learned counsel for the petitioners and also MS. So it's record is, record is received. List for admission hearing after a week. We'll dispose it after a week. Number 24. 24. What
Your
is
Price
this?
Lordship.
Ah,
Lordship, this is an make appeal
hmm.
against the award passed by the MSCT Tribunal Laws 130.
Hmm.
Lordship, I am challenging the quantum of compensation. Lordship, just there is no dispute regarding to the fact of the case and regarding the insurance policy also. The only dispute here is, my lord, Your Honor,
that the claimant is the elder brother of the deceased, who is 85 years old, and he has his own source of income. So he's not dependent on the family or on the deceased, Lordship. So learned tribunal has wrongly aided in awarding a compensation under the head loss of dependency. Lordship, my contention is that the deceased, since he has own source of income, is not dependent on the deceased. So if he is entitled to compensation, he is entitled under the head loss of estate. So that's my case. Lordship, I placed the judgment of our Guwahati High Court regarding loss of dependency. It's in the record.
Yes. He was not dependent.
Lordship?
He was not a dependent.
Lordship, my claim is that he is not the defendant of the
Yes.
and there is no evidence on record.
He is
to
not
show-
a dependent.
Yes,
He's a brother.
elder brother of the deceased, who is
Ah.
85 years old.
Okay. So how much amount has been granted? How much awarded?
Lordship, 23 lakhs, and along with interest, it comes to around 40 lakhs. If it's in a loss of dependency, and if it's in loss of state unit, it comes to around 20 lakhs.
So half of the
Yes.
thing. Do you agree?
My lord, no, my lord.
Was there any evidence to show that he was
No,
dependent?
Your Honor, they have not brought any evidence on record to show that they are dependent.
Actually, my lord, in my humble submission, my lord, in this motor accident claims, dependency, my lord. My lord, even if, my lord, the claimant is not dependent on the deceased man, being a legal representative of the deceased man, they are entitled to compensation. And law is settled on their front. My lord, if my lord is hearing on the matter, my lord, I will, my lord, first whip out the fact how this compensation is awarded by the learned tribunal. First, my lord,
We'll take up next week.
next week, man.
Hey.
Lordship,
I have not seen the file.
In this case, initially, the younger brother of the deceased had filed claim petition. Then during the pendency of the case, the brother expired. So his elder brother, he was substituted as legal representative. So since a dependent person who has died, whether the brother who is eligible, who has his own source of income is entitled to compensation under a loss of dependency.
So according to he being an elder brother, he is not a dependent
Yes.
of the disease.
My lord, even
In
in a
fact,
claim,
the younger brother was dependent.
yes. And Lordship, even in the claim petition, there were two sisters who were dependent on the deceased, but they were nowhere out in the picture after the claim petition has been filed. Had the elder brother filed the petition on behalf of the sisters also, they would be entitled to compensation under the head loss of dependence.
Record is there.
Yes, the record is come.
This case needs some exhaustive hearing.
Hmm?
This case needs some exhaustive hearing because certain law points are involved. My lord,
Exhaustively heard.
It's need exhaustive hearing.
Exhaustive hearing.
Yes,
The issue involved.
yes.
So when do you want?
My lord, I'm ready to the man.
Lordship, but the case is clear. Our Honorable High Court has already passed
So
this.
here it's a hearing still that you would like to see.
And regarding the case which is placed by another friend, my lord, is so from our High Court. My lord, while delivering this judgment, my lord, the dictum passed by the Honorable Supreme Court has to be placed before the Honorable Court. That's why this order has been come up, not this judgment has been come.
Next week
Next week,
or afternoon.
next week if possible, my lord.
Next week.
Yes.
On the joint prayer of learned council for the parties, list this matter after a week. We'll see.
My,
This is not brought to my residence.
my lord.
File was not sent yesterday.
Okay. Yes, my lord. It has to be listed for today, my lord. But because of mistake.
Yes, they told me.
Yes.
Yep.
Yeah, but it's come up for supply.
Next week we'll see. All right.
My lord.
Please, my lord, in item number 16, interim was there, so.
Country board first earlier shall continue. When it is to be taken up?
After 1 week, my lord.
After 1 week.
Yes.
Can you take it up at 2 o'clock? 2 o'clock,
Okay, my lord.
item 16. We have it. Huh? You inform the other side. PP, huh?
Okay, my lord.
2 o'clock we'll take it up.
Okay, my lord.
Here. No one is there. You have to finish that. Huh? Call somebody else. Yes, we thought we have the time, we'll dispose of this matter. Okay.
Lordship.
What is your stand?
Lordship, as the Lordship, Elster has come, Lordship. If possible, let the matter be fixed for admission hearing.
No, this was admission hearing only. Huh?
Lordship, because as per my this learned colleague, Lordship, she asked me to appear, Lordship, so that she was forgot to mention this last interim order to be continued.
No, then we have allowed that and then.
Lordship. Then Lordship is up to Lordship. If Lordship can.
What do you say? What is your submission?
See, my submission will be Lordship because this is Lordship. They have already mutually settled the matter, Lordship, amicably, as they have annexed the amicable settlement, Lordship.
It's
Legal
380.
settlement.
Can it be?
It is non-compoundable, your lordship. However, your lordship, the apex court in Ketina of judgment has interfered in such cases which are predominantly which have civil character, and particularly those arising out of family dispute, minor misunderstanding, your lordship.
So what your this thing comes under?
This is not civil dispute, is not comes under lawsuit. It is criminal lawsuit, but moreover, it is private in nature. It cannot be, it is not a grievous lawsuit, serious in nature lawsuit. It can be lawsuit compounded lawsuit.
You have admitted also. What is the settlement?
Settlement, it is in annexure to page number 39, your lordship. Basically, there was some minor misunderstanding only, your lordship. And even this honorable bench has another matter was pleased to quash and set aside a criminal petition which was registered under. May I rely upon this matter, Your Lordship? In this case, Your Lordship, the Honorable Court has relied upon the judgment of Ram Gopal and other versus State of Madhya Pradesh, along with Krishna Appa and others. It is in para 7, Your Lordship. May I read the relevant portion, Your Lordship? Para 7 and or para 7 of this judgment, Your Lordship.
This is under section?
This was under section 4. This was under section 181, 192, and 196 of Motor Vehicle Act, and 181, 192 is of IPC, Your Lordship, and 96 is of Motor Vehicle Act, Your Lordship. Your Lordship, even if the case proceed further, there is less chance of conviction, since the party they both have amicably settled the matter, and then moreover, if it proceed, it will abuse the process of court, Your Lordship, and then if the request of the parties is denied, it will be amount to only adding one more criminal case to the already overburdened criminal court, Your Lordship. The alleged accusee doesn't have any criminal antecedent, Your Lordship. And moreover, considering her age, she is in her mid-20s, and if the said matter is not set aside by this honorable court, it will ultimately prejudice her career, Your Lordship, which will.
Stay is already been granted, Lordship. Here.
Are you brothers, sisters?
Yeah, yes, I am the aunt. I'm the aunt. Petitioner number 1. She is the aunt, and one alleged accused, she is the niece. Your Lordship can.
Maternal or paternal?
Yes, Your Lordship.
Maternal or paternal aunt?
Maternal, Your Lordship. Your Lordship has the discretion to exercise power under 482, since it was because of some minor misunderstanding only.
But you have clearly admitted, page 32.
However, Lordship, even though it might, even though 161, alleged accused might have admitted, but it cannot be accepted as a substantial piece of evidence, Your Lordship. 161, it's not a substantial piece of evidence, Your Lordship, and.
Yes. So, will allow.
After discussion of this court, Lordship.
Heard MS
A. Talom.
A. Talom, learned counsel for the petitioners, and also heard MS L. Hage, learned additional PP for the state. By filing this application under section 482 of CRPC, 1973, the petitioners have jointly praised for quashing of the criminal proceedings,
Yes, Your Lordship.
pending criminal proceeding being JR case, criminal proceedings of JR case number 588 of 2022 and section 380 of the IPC, 1860 corresponding to eternal PS case number 285 of 2021 pending before the Chief Judicial Magistrate, learned Chief Judicial Magistrate, UPI. Where is that FIR?
FIR is says page number 18, Your Lordship, Annexure 1.
18.
Yes.
The handwritten, the type copy. The present criminal proceedings emanates from the FIR lodged by the petitioner number 1.
Yes.
Petition number 1 on when is the date of FIR?
FIR 02/07/2021.
02/07/2021 before the officer in charge, Ethanol Police Station. Stating that she had lost her ATM card of Canara Bank, Eternal Branch saving account number 110000190926 on 19/06/2021. She thought that she has misplaced the card somewhere else. However, while she visited the bank on 02/07/2021, it came to her knowledge that someone else had withdrawn an amount of ₹20,000 from the Canara Bank ATM. Through her Canara Bank ATM. On the request of the informant, no. It is stated that on the request of the informant, and on the bank official had checked the CCTV footage, and it was found that one of her friends, namely MS Yangaram Singh Mara, petitioner, has withdrawn the money from her account. The informant has stated that the petition number 2, this is accused petition.
Yes, petition number 2.
MS Yangaram Singh Mara is one of her friends who regularly visits her house and alleged that she had stolen her ATM card and committed the crime. Pursuant thereto, on receipt of the said FIR, a case has been registered being Eternal PS case number 285 of 2021 under section 380 of IPC, and 1860 Mr. After investigation, after next para, after completion of investigation, comma, a charge sheet has been laid before the court. Where is the charge sheet?
Charge sheet is, page number 28, Your Lordship, annexer 3, or annexer 2. Page number 28.
On 03, laid the charge sheet before the court on 03/09/2024. Is it 24?
Charge sheet,
Yes.
yes,
2021 or 2024?
2021, Your Lordship. Charge sheet number 311/21.
No, which date? This is 2021,
Yes, 2021, 03/09/2021.
03/09/2021, right?
Yes. Your Lordship, initially investigation officer, they have charge sheeted under 379 of IPC. However, the learned trial court have framed the charge sheet under 380 of IPC.
379 is what?
The punishment for theft. But however, learned trial court, she had framed the charge sheet under 380 of IPC.
379 is charge
370.
sheet, Mr. On so and so, Mr. Continue. No, charge sheet was laid before the court under section 379 of IPC against the petition number 2, Mr. The learned court, trial court has framed the charge under section 380
Yes, sir.
IPC. So and so. Thereafter, charge has been framed against the petition number 2 under section 380 of IP, 380, IPC from 1960. How many prosecution witnesses have been examined?
No one.
Charge has been framed.
Charge has been framed. It was in PWS stage, evidence stage.
Taxpayer. MS.
A talong.
A ton of learned counsel for the petitioner submits that the informant, that is the petitioners and petitioner number 1 and petitioner number 2 are closely related,
Yes.
being the petitioner number 1, being the maternal aunt and the niece list of. So, a charge sheet has been filed on the basis of the statement under section 161 of CRPC by the petitioner number 2, the allegation has been due to misunderstanding between the petition number 1 and petition number 2. Just having realized that, the parties have entered into a settlement. Page
39, annexer 3. 39 to 42.
that the complaint public FIR has been they filed by the petition number 2. They being the no. Considering that the petition number 1 is the aunt of petition number 2, and on the intervention of the family members and well-wishers, they have decided to settle the misunderstanding amicably. Accordingly, by settlement dated by deed of settlement dated 18/11/2023, they have entered into compromise, entered into settlement. And to have a peaceful and amicable, peaceful and cordial relations. Lister. Next paragraph. MS so London Council, further submits that, not further, submits that in view of the settlement entered into between the petitioners, there's no, the chances of conviction, the chances of conviction are remote and bleak and remote. Therefore, she submits that the present, the criminal proceedings be worse. Maybe worse. Next paragraph. MS El Hage Register PP. Fairly submits that the petitioners being relatives, the petitioners appears to be relatives, appears to be relatives being aunt and niece, and they have already settled the matter by executing a deed of settlement. Though the charge sheet has been filed, though the charge has been framed against the petition number 2, in view of the such settlement, the chance of conviction is remote, and therefore, if the proceedings is allowed to continue, same may be abuse a process of the court. Next paragraph. I considered the submissions of the learned council to the parties and also the materials available, the reports. Records reveals that no. Next paragraph. Records reveals that the charge sheet has been filed under section 379 IPC. And the London court has framed the charge under 380 IPC, 1860. The petition number 2 has petition number 2 and statement recorded under section 161 of CRPC as indicates that the petition number 2 has withdrawn the amount by using the ATM card of the petition number 2. She has stated that in the petition number 2 had stated that she has taken Didi's ATM, that is petition number 2, which was kept in her bedroom from her handbag and drawn the amount. Thereafter, on the basis of the CCTV footage, an FIR lodged by the petition number 1. However, after the charge sheet come up, the petition number 2 and petition number 3, petition number 1 and petition number 2, who are relatives, being maternal aunt and niece, entered into a settlement agreement, entered into a settlement by dated 18/11/2023.
Yes, it has been duly notarized by the notary officer.
And have decided to live peaceful and cordial relationship thereafter. Peaceful and cordial relationship. Although the petition number 2 has stated to have taken the ATM from the petition number 1, it appears that it cannot be said that the petition number 2 has stolen the said ATM. Be that as it may, the petitioners have entered into an agreement, settlement. Next, in the case of so-and-so, State of Madhya Pradesh versus Lakshmi Narayan, where is that? 2017.
Lakshmi Narayan Worship, 2009.
What is that?
2019, Your Worship.
2019?
Yes.
Hmm?
Yes, 2019.
Hmm.
There are 13 operative portion is full.
No. So and so reported in 2019. I think it's there. The final, huh? The Honorable Supreme Court has held, which is reproduction. There are 15, huh? 15 to 15 point something. Next one. In the present case, the petitioners, being informant and accused, have jointly filed this present application and has pressed for quashing of the criminal proceedings, being the criminal proceeding of GR case number
588.
Mr. Both the petitioners are relatives, being maternal aunt and each. Mr. It appears that no. It is not a case where the unscrupulous offenders have attempted to escape their criminal liabilities by securing a compromise through brute force, threats, bribes, or other such unethical and illegal means. And the settlement has not been struck post-conviction. As noted above, though the petition number 2 has stated to have taken, admitted to have taken the ATM card of the petition number 1, being the relative, it cannot be strictly said that the petition number 2 has stolen the ATM of the petition number 2. As their relatives, and it is due to misplacement, it is alleged to have been due to misplacement of the bag or purse of the petition number 2.
Yes.
Right?
Yes.
You have misplaced your bag.
Yes.
And the purse, so you have taken your auntie's ATM from the bag. Anyway, please stop. Next paragraph. The touchstone for extraordinary, not inherent power of this court under section 482 CRPC is to secure ends of justice. This court is not oblivious to be born to fact that the power under section 482 CRPC has to be used sparingly. But at the same time, it is to be noted that the rigid and spacious justice may also lead to grave injustice. In the facts of the present case, I am of the view that further proceedings and continuance of the, no. Yeah, please stop. I'm of the view that even after the settlement between the parties, if the proceedings, criminal proceedings is allowed to continue, apart from chances of conviction being bleak and remote, and it would cause the great, it would cause an extreme injustice to the petition number 2. Please stop. Please stop. Considering that the parties have resolved the dispute between them, it would help them to maintain peaceful and cordial relations between the parties. There's a settlement definitely would improve the relations of the parties as their relatives, as their relatives. Next one. Considering, in view of the above, in view of the discussions made here in above, and of the considered view that this is one of the cases, one of the cases where the inherent power of this court under section 482 of CRPC is fit to be invoked. Accordingly.
Lordship, here, Lordship, nowhere it says written that they have relationship, their family relation, Lordship. As per the FI, Lordship, he is one of her friend, Lordship.
No, in the statement is there. In the statement there. That's why records is there.
Okay, Lordship.
The statement, the FI recorded that.
Yes.
Accordingly, accordingly, the criminal proceedings of GR case
588 of the 2020.
588 of 2021.
2022.
2022. In the section 380 of 380, IPC of 380 of IPC, 1860, pending before the learned Chief Judicial Magistrate, UPR, is hereby quashed. The petition community is the instance allowed at this point.